tenant.
Mr. Carrick.
Yes. May it please your lordships and my lady, I appear on behalf of the appellants together with Miss Siobhan Gerald, and to my left is Mr. Claude Hogan, who is actually a pupil from Montserrat. The respondents are represented by Mr. Rowan Pennington Benton and led by Daniel Feetham QC.
Yes, thank you.
Before I open the appellant's appeal, there are some housekeeping matters relating to documents. There are a series of documents contained in the second bundle, and it's quite a few, between pages 358 and 739 of the electronic bundle, which both sides agree ought not to have found themselves in the bundle.
And just remind us what those documents are, broadly.
Page 358.
Yes, but what do they go to?
They are basically, in the main, documents that post-date the Court of Appeal decision.
I see. Thank you.
And documents which were not before the High Court, and some documents which were attached to the counter notice of appeal in the Court of Appeal in Montserrat, but then rejected by the Court of Appeal. In essence, fresh evidence which the Court of Appeal did not entertain.
Very well. So we should disregard those documents.
Yes, I'm grateful.
My lord. Page 358 to what?
Yes.
What was the end page? Please.
Sorry, I do apologise. It was at 739.
Thank you.
739. But amongst those documents, my lord, are some documents which the respondents wish the board to take into account and which we object to. The first document is at page 393 of the bundle, and that's a letter dated the 19th of September 2007. This was not before the High Court. It was exhibited to the respondent's counter notice of appeal and not admitted by the Court of Appeal. The second is a letter dated the 9th of May 2008, and that's at page 413.
Before moving on to the second one, the counter notice of appeal, is it the same counter notice of appeal in this court?
It's similar, my lord, but it's not the one in this court, but it's similar. But at page.
Well, why are we looking at all these when you?
Well, that's the point.
Not that we shouldn't be looking at them.
No, I'm saying the other side want them in, and I'm saying they should not be in. But maybe I should leave my learned friend to say why these documents should be in rather than.
I have to say that seems to me to be a much more desirable course with respect, because it may be that they're going to have very little, if any, bearing on any issue that we have to decide, in which case it isn't going to be a good use of our time today to be exploring the issues around them.
Yes.
So we'll proceed on the basis, for the moment, that you're not going to take us to anything in 358 to 739.
Yes. There's one further document which both sides agree does stay in, and that's there's been a recent conviction of Mr. Castle relating to the proceeds of crime.
Yes.
That's at 735 to 738. So
we should look at those documents.
You should look at those documents. We're agreed. It doesn't take the matter much further because, of course, the case in the High Court and in the Court of Appeal proceeded on the basis that Mr. Warren Castle had acted fraudulently.
Yes. Well, we've read the judgment of the board.
Yes.
Dealing with the remission back of the issues, which, as I understand it, this now resolves.
Yes. So, my Lord, this case concerns the sale of some 11 acres or so of cliff-top land on the northwest coast of Montserrat overlooking the Caribbean Sea. And it's 11 or so acres from land owned by Providence Estate Ltd. Providence Estate is a Montserratian company that was incorporated in 1989 with 2 shareholders. The majority shareholder was Mr. Walter Wood. He owned 60% of the shares, and the minority shareholder was the second respondent, Mr. Owen Rooney, with 40% of the shareholding. The idea was that the land at Providence Estate, which is about 52 acres in all, would be developed by the second respondent. However, by 1992, the development project had failed, and the company lay dormant until 2001, when it was struck off the register. Each of the appellants in this case purchased their land separately from Mr. Warren Castle.
Could I just ask you, the directors of PEL, which is I think what we're all calling it.
Yes.
The first directors were a Mr. Weeks and a Mrs. Weeks, is that
yes, I think Mr. Weeks certainly disappeared from the picture quite early on, as well as Mr. and Mrs. Yes, as well as Mrs. Weeks as well.
And then at that point, but it isn't quite clear when, as I understand it, Mr. Wood and Mr. Rooney became
yes.
the only 2 directors
the
of the
only
company.
2 directors of the company, yes. So the appellants were firstly Mr. Brelsford. He's a British gentleman and was employed by the British government in Montserrat as the Director of Public Works.
Yeah.
He paid 216,000 EC dollars for parcel 15, and the intention was to build his retirement home there. He is now retired. He's about 70 years old and lives in North Wales. The second appellants were Mr. and Mrs. Krause, a retired American couple who purchased the land when they visited Montserrat on holiday. They were the owners of 131014, so parcel 14, and they paid 537,300 EC dollars for their land. Mr. Krause is about 81 years old. Joel and Ingrid Osborne are Montserratians. Mr. Osborne is a retired civil servant. Together with his wife, they purchased parcel 56. And that was for around $67,500. And then Kenneth Allen QC, a retired QC, purchased parcel 59, and that was for over $400. Mr. Allen lived on the border of Providence Estate at Jones Hill, and he wished to purchase the land for his children and his wife. His wife is Appellant 7, Yvonne Daly-Weeks. His daughter, Kathleen Allen Ferdinand. And his son, Mr. Carl Markham. None of the appellants were known to each other, save for Kenneth Allen and his children. I think he also may have known Mr. Osborne, but they all purchased separately, came separately, and each separately negotiated prices with Mr. Warren Castle. By 2008, my lord, Mr. Castle's fraud had been discovered. And that set off a flurry of correspondence from the second respondent to various persons, including the government and also the lawyers who handled the conveyancing. And the lawyers who handled the conveyancing were Mr. Carl Markham and Mr. David Brandt. As a result of that, in 2012, the appellants each issued a fixed date claim seeking essentially declarations as to their ownership and entitlement to the land. Each of the pleadings were materially identical. And they start at page number 1 of bundle 1. There was a date for the fixed date claim. The first hearing was on the 26th of April 2012. And on that date, it appears that Mr. Rooney filed an affidavit, or affidavits contesting each of the claims. And the first affidavit appears at page 41 of the bundle. And your lordship will see the date stamp at the top of right-hand side of page 41, which shows the date that it was filed. Now, it was the appellant's case that this document was never served on the attorneys acting for the appellants, that's Allen and Markham. And it came to light later on. But we say it wasn't evidence for the case in any event, because on the 26th of April, directions were made, and in particular, directions were made for the filing of defences, and witness statements. A defence and counterclaim.
The proceedings came on the 26th of April.
It came on because it was a fixed date claim in Montserrat.
But in fact, directions were made on that day.
Directions were made on that date. And
claim.
Yes, and it's unclear Well, it's actually very unlikely that it was before the judge on the 26th of April, because the judge would have made some directions about that affidavit, but what the judge did was to order a defence and counterclaim to the statement of claim. My Lord, the fixed date claim procedure is a claim whereby the court issues a claim and issues a date straight away. That's under the Eastern Caribbean CPR 5 and 27.2.
Yes, as far as it matters, do we have the directions for?
We don't have the directions, my lord, but we do have later on in the transcript we have a discussion about Mr. Rooney's failure to serve a witness statement, and so when we come to that, we will see it from there. But the whole point is that I wish to make is that this, when it comes to a fixed date claim, on the first date, the judge has a discretion whether or not to hear the trial summarily or to make directions that it proceeds by way of a normal trial. And that's CPR 27.2 and 2 in particular. But what we say happened was this: was that those directions were made, and then there was the filing of a defence and counterclaim, which the board will see at page 77 of the bundle, which represents it's identical counterclaims in relation to each respondent. But the relief that was being sought at page 79, and it's a defence and counterclaim served by the first defendant only, that's the company PAL. On page 79, you see the relief that was being sought, a declaration that the claimant is not a bona fide purchaser for value, rectification of the land register to restore the status quo pertaining prior to the impugned land transfer. 3, a declaration that the claimant has been unjustly enriched at the expense of the first defendant, and this is an argument that you will see in the respondent's cross appeal, and restitution. So that was the counterclaim. The trial took place before Mr. Justice Bristol, where each of the appellants gave evidence. And that trial took place on the 20th of April 2016. Each of the appellants filed similar witness statements, and each of the appellants gave evidence and were cross-examined by Mr. Rooney. And it's instructive to consider very briefly some of the notes of evidence that were given. Mr. Kenneth Allen, the notes of his evidence start at page number 192. And over at 193, the last question on the page is, were you associated or related with Mr. Castle in any way whatsoever at the material time, that is the period leading up to the transaction and actual transaction? And on 194, he says, I was not. He's then asked, were you aware of any dispute between Mr. Owen Rooney, the first defendant, and Warren Castle?
It's actually his examination in chief, I think you're reading from.
Sorry?
I think you're reading from his examination in chief.
Yes, that's in his examination in chief, yes. I do apologise. Were you in any dispute between Owen Rooney and Frederick? Then in cross-examination, at page 195, he's asked a series of questions by Mr. Rooney, and in particular, I do apologise, 194. Did parcel 131059 come into existence on October the 30th? And he says, I don't know when that parcel came into existence. The land is adjacent to my house and I was able to point at it. I knew the land. But I've asked you to note that because when it comes to the argument later on about the admissibility of a certain affidavit that was never in the proceedings, never before the court, it will be my submission later on that the only reason that this affidavit is being put in is to somehow contradict the evidence given by Mr. Kenneth Allen. The point is, during that cross-examination, it was never put to Mr. Kenneth Allen that he was complicit in the fraud, or that he knew about the fraud. And the position was the same with each of the other appellants. Neither was it put to them, as the respondent's case now says, that they knew the lawyers.
Just trying to orientate myself around it. Mr. Castle, you agree that Mr. Castle committed a fraud, is that?
There's no dispute about that, but what we say, my lord, is that the appellants were all innocent purchasers and did not know about the fraud.
And could Mr. Castle have perpetrated the fraud if the purchasers had made proper inquiries?
Well, my lord, the position is that there was an application to restore the company, and in Montserrat, such applications are put in the local newspaper. And then the matter went to court, the application went to court, and the court made an order restoring the company to the register. And we say, and there's a Caribbean case that I'll refer to in due course, that it was not necessary for the attorneys to look behind a court order, because we say that court order was valid until it was set aside.
I don't think anybody's contesting that the PEL was restored to the register, and therefore was a valid company. But I suppose my question was, well, Mr. Castle perpetrated a fraud by virtue of the fact that he didn't represent the company.
Yes.
And so I was asking whether or not Mr. Castle could have perpetrated that fraud if the purchasers had made inquiries.
Well, the difficulty I would submit is this, is that if the attorneys looked at the company register, they would have found that Mr. Castle was indeed registered as a director of the company and the main shareholder. They looked at the land register, the property register, and there was Pell registered as the proprietor, with Mr. Castle as the representative, and giving the address, Mr. Castle's Ulverston address for the company.
Yes. Some of the details that you're giving us aren't, I don't think, in the agreed statement of facts and issues.
Yes, but they are in the point I'm making is that they are nevertheless.
Do we need to know the details of when the company was restored to the register, what the effective registration is, and who were the directors once the company was restored?
Yes, it was restored in...
Would that be helpful for us to know?
Yes. It was restored, I was going to come on. It was restored in 2001 with the director being Mr. Castle.
It was restored in 2007.
This is 2007, I do apologise. And it's...
as I understand it, it was struck off in
2001 and restored in 2007,
and
yes.
At some point, while it was struck off, am I right in understanding that Mr. Wood purported to transfer his shares?
Yes, Mr. Wood purported to transfer his shares, and we can see the document at page 276. It's not very legible, but that's the transfer of shares there, and that's before the company was restored. Then,
so whatever the effect was, there was a purported transfer.
Yes.
In 2007.
Yes.
To Castle and Lewis.
Yes.
And that was the firm, is that right?
That Castle and Lewis, yes, was Mr. Castle's legal firm. Yes.
And so, I know there were proceedings in Virginia, which we may or may not need to come to, but leave that on one side. In 2007, Castle and Lewis applied to have the company restored to the register.
Yes.
Is that right?
Yes.
And am I right in thinking that is at bundle 141?
Yes. Yes, so that's at 141.
And that application says that the application is made by Mr. Castle of Castle and Lewis.
Yes.
Have I?
That's correct, and that's correct. At 142 and 143.
And that happened on the 9th of August.
Yes.
2007. And then, as I understand it, from your submission, in September 2007, the company was restored.
Was restored, yes.
And can you give us the relevant provision of the Companies Act under which it was restored?
That was, I do apologise, I'll get that to hand now.
Is it section 483?
Yes, it was. I do believe I've got that now.
And is the relevant provision at page 859?
Yes. Yes.
So the application was made under subsection 6?
Yes.
Purportedly, as I understand it?
Yes.
Now, you're telling us that at this point, or around this point in time, there was a change in the directors, is that right?
There was a change in the directors indeed.
And what happened?
And we find that, I do apologise, I just had the page.
Just before, I think, 144, the one we were looking at?
Yeah. I do apologise, my lord, I had it.
144?
Yes, 144. Yes. Yes, there's a change of directors.
Now, this purports to show that Mr. Wood and Mr. Rooney both ceased to be a director, but that Mr. Castle became a director.
Yes.
And from this time, Mr. Castle was purporting to act as the sole director of the company.
Yes, he was.
Is that right?
Yes.
The validity of these various transfers and orders and so forth may be open to question, but this, as I understand it, is the chronology as presented by Mr. Castle.
Yes.
Is that right?
Yes, it is. And we say that looking at the company register and also the property register, there was nothing that excited suspicion at that stage so that further inquiries should be made. And in fact,
what did the judge say about that? Which part?
The trial judge found that any lawyer worth their salt would have made those inquiries. That was his finding of fact. But so far as the appellant's attorneys were concerned, the leading decision in the jurisdiction at that time was a case called Pickering, Jury, Wilkins, and the Register of Lands. That was the leading, and we can find that at page 1257 of Part 2 of the authorities.
And what proposition do you say this supports?
That was, we say, the law in the Eastern Caribbean at the time. It's a judgment of the BVI High Court by Madam Justice Harry Prashad Charles. And if one looks to page 1267, at paragraph 29, first of all, Madam Justice deals with the effect of Section 38 of that Act and the decision in Fraser and Walker. Then at paragraph 30, the land judge says the overriding object of the Torrent system of land registration upon which Act is based is to achieve greater simplicity and certainty of title to land by a system not of registration but of title by registration. The system confers on the registered proprietor general indefeasibility. She goes on to say that on the facts of that case, therefore, GCS were entitled to rely without further investigation on the official search provided by the Register of Lands and the Land Register. GCS was under no obligation to investigate the history of the circumstances of the vendor's title. It was enough for GCS to only look on the face of the register relating to the land to determine the totality of interests or rights affecting the land at any given time. So that was, we say, the settled law.
Anyone is contending that PEL didn't own the land at this stage. Theirs was the name presumably on the land register.
Yes.
But this is what we're thinking about now is not any questioning of PEL's title. It's the questioning of whether Warren Cassell was the right person to be purporting to sell the land. So I think what you were saying, as I understood it, was that if people had looked at the register, they would have seen that he was the sole director of the company once it had been restored. And then you also took us to their cross-examination to say it wasn't really put to them that they were complicit in this or that they had failed to make adequate inquiries.
Yes.
Now, what they seem to have said, or the one who showed us, was, well, I had a lawyer who dealt with all that. But did the lawyers give evidence? The lawyers who had acted for the appellants?
No, they didn't. There were two lawyers, my lady. One was Mr. Markham himself, who was acting for the appellants.
Well, at the time of the conveyances?
At the time of the conveyance, yes. And he was also trial counsel on behalf of the appellants. And also, there was Mr. David Brandt, who acted for two of the appellants. He acted for Mr. Brelsford and Mr. and Mrs. Krause.
At what stage did he act?
At the conveyancing stage. So he was the person. So both Mr. Markham and Mr. Brandt dealt with the conveyancing.
Right, and they didn't give evidence?
They didn't give evidence at the trial.
So it was not put to them that they should have made these inquiries?
No, it wasn't put to them at all. It was the trial judge's suggestion that they ought to have done this. Well, his finding, in fact, that they ought to have done this, that any lawyer worth their salt would have gone behind the court order, would have looked at various resolutions to make sure that Mr. Castle was who he said he was, a director of the company.
So can I just be clear where your submission is going? Are you actually challenging the finding of fact that there was constructive notice?
Yes, I do challenge that,
and on
my
what
lord.
basis are you doing that, given as I understand it, we've here got a finding of fact which has been upheld by the Court of Appeal. On what basis are you coming to the board to ask us to go behind concurrent findings of fact?
Well, I say that in the circumstances that it simply wasn't open to the trial judge on the evidence to come to that conclusion without actually hearing any evidence on the issue. If the trial judge had said during the course of the trial, well, look, I'm unhappy at this stage because I think the lawyers should have done this, and I think there should have been evidence about this, then that would have been one thing, and no doubt, certainly Mr. Brandt would have been called to give evidence at the trial. But I say...
So where does this fall within the Devy and Roy cases, in terms of situations where we can depart from our strong practice not to go behind concurrent findings of fact? Well, where have you put this in your case to the board?
Well, I would submit to the board that in this particular case, where we have a torrent system, where there is a strong practice, not just in Montserrat, but in the Eastern Caribbean generally, not to go behind the property register as such, that this was a finding that was not open to the learned judge to make.
Well, with respect, that seems to me to confuse again the point that was put by my Lady Rose, that we're not talking about that aspect of notice. We're talking about the conveyancing transaction.
Yes. Well, my lord, what Mr. Justice Bristol held was that had the appellant's lawyers carried out what he termed as being the necessary inquiries.
Can you refer me to the actual page of his judgment?
Yes. The judgment begins at page...
Is it page 247, paragraph 71?
Yes.
You've referred us to two documents, the second being a company's registration, so that I understood your submission to be that if indeed somebody had looked to see on the company's register as to whether or not Mr. Castles had title to the property, that there would have been nothing to excite their suspicion. But there's a finding at page 294, paragraph 3, that there was no evidence or indication in the judgment that a notice of this appointment was filed at the company's registry. So they wouldn't have found it.
Yes.
That was the company resolution removing Mr. Wood and Mr. Rooney and appointing Mr. Cassell as director with effect from the 1st of July, a date in which the company was still struck off. But there was no evidence or indication that a notice of this appointment was filed in the company's registry. How do we know it was filed in the company's registry?
Because those documents, my lord, were at the trial, and during the course of the trial, some documents were sent over from the company registry. And there's a discussion about it right at the beginning of the trial. Let me get that for you. I apologize. Yes, it's page 191, where he talks about the documents. Mr. Markham, the copies of the registrar sent across to you from the company's registry, they all have the stamp, so if there's any difficulty, let me know as we go through. Just to be clear, and for the record, these documents are not evidence as to the facts stated. They're just there to show that they were, in fact, filed and on public records. We're not relying on them to the truth of the contents by any means. So there were documents, and then those documents found themselves in the bundle, which were before the High Court and before the Court of Appeal also.
So these are the documents underpinning the observations by the Court of Appeal at paragraphs 1 through 5 of the judgment.
Yes, they are.
Of Justice of Appeal Carrington.
Yes.
So we've now got the picture, we've seen the documents, we've seen what the Court of Appeal said about them.
Yes. But it's my submission that in any event, that the appellants all still remained, in my submission, innocent purchasers. There was no knowledge of the actual fraud.
No actual knowledge?
Sorry?
No actual knowledge?
No actual knowledge of the fraud.
And
that's a finding made...
What about constructive knowledge?
So I do apologise.
What about constructive knowledge?
I say the court was wrong to say that amounted, the failure to make those inquiries amounted to constructive knowledge, because nothing would have been discovered. But so far as actual knowledge is concerned, the Court of Appeal accepted that there was no actual knowledge because it accepted that this was not a case where the court could rectify the register under Section 140 of the Registered Land Act. I'm just looking for the passage in the judgment, my lord. I want to apologise. I do apologise for the delay. I get the message that I was looking for.
Paragraphs 49 and 50, page 308 to 9.
I'm grateful, my lord. Yes. Justice of Appeal Carrington said at 49, Registered Land Act Section 140 permits rectification by the court only upon the incurrence of two conditions, both of which must be present, where registration has been obtained, made or admitted by fraud or mistake. The registered proprietor, in the instant case, the purchaser had no knowledge of the omission, fraud or mistake, in consequence of which the rectification is sought or caused such omission, fraud or mistake, or substantially contributed to by act or default. And the court accepted that in this case, the register could not be rectified by virtue of Section 140 of the Act, so went on to deal with the personal claim. And
well, they said at 50 at the end, they say there's a case that says it must be actual fraud.
yes,
And then they say, in the absence of a finding of fraud or mistake, the conditions for rectification of the register do not arise.
yes.
So they make that jump from fraud to mistake. But what's the basis for saying that because there was no actual knowledge and hence no fraud, that there was also no mistake?
Well, so far as the mistake is concerned, my lady, under Section 140, there has to be a mistake which the registered proprietor has contributed to. And in the present case, the appellants had not contributed to any mistake on the register. That was solely down, if there was a mistake, it was solely down to Mr. Castle, but nothing to do with the appellants.
Well, is this the same submission in effect that you say they didn't have constructive notice?
Well,
because if they did have constructive notice, why wouldn't one say that they have substantially contributed to it?
Because, my lord, that under Section 140, we say that only actual knowledge suffices. So they would have to have actual knowledge of the mistake, just as they would have to have actual knowledge of the fraud. And that is why the Court of Appeal couldn't proceed by way of Section 140 to rectify the register.
Well, I can see that in relation to 49, the first part of 49.2, because
yes.
It says had knowledge of,
yes,
and it may well be read as actual knowledge of.
yes.
But what about the last part? Whether rectification is sought or caused such omission, fraud or mistake, or substantially contributed to is by his neglect or default. Why isn't it arguable, or what do you say against the argument, because I think this is actually put to you
Yes.
by the other side, that if we're against you on the constructive notice point,
Yes.
why wouldn't that constructive notice constitute substantially contributing to the fraud or mistake by neglect or default?
Well, my lord, I would submit that in these types of cases where one's dealing with the register, the bona fide purchaser, who is essentially innocent, should not be penalised by something which the lawyers did not do. And it's clear from the evidence that at no stage did the lawyers ever communicate anything to the appellants which would suggest they had to look again at this transaction.
Yeah, but you have to, don't you have to ascribe the lawyers' acts to them? Otherwise, everyone would always escape liability by saying, oh, it was my lawyer's fault. So assuming for the moment both the point that my Lord Burrows makes, which is that we're against you on the constructive notice point, and also that they are not therefore innocent because what their lawyers did or didn't do is treated as what they do or don't do, why is it that that kind of neglect or default, why do you say that neglect or default does not substantially contribute to the mistake that then appears on the register?
Well, maybe the first point is that so far as the mistake is concerned, the mistake is, in my submission, caused by the government itself, the Registrar of Lands, by accepting that Warren Castle is a director of Pell and has authority to deal with Pell. The mistake is also caused by the Registrar of Companies accepting that the company is properly restored to the register, that Warren Castle is able to deal with his property, because the information from the Registrar of Companies goes to the Registrar of Lands to make the necessary amendment to the register to show that Warren Castle is the director and that the address of the company is now Warren Castle's address. So I say...
Sorry, you're saying that that information appears on the land register?
It appeared on the land registry, yes, that Warren Castle was the director of the company. So this is not a case where the appellants, as it were, treated with Warren Castle, not having discovered, as it were, that he was represented on the land register.
So whereabouts do we turn to find him?
Well, it's unfortunate that that's the one document that we don't have. But they couldn't have dealt with Warren Castle unless he was named on the register.
On the land register?
The land register, yes. What happens is, where there is a company on the land register generally, what happens is that a director or representative is named on the land register.
Giving evidence.
Sorry? Sorry, I can't hear you. Sorry, it was... Oh, I thought you had Warren Castle's address on it. Yeah. All right, I'm told that it was Warren Castle's address on the register. And was it Castle and Lewis as well? Okay.
Pell would have appeared on the register.
Pell appeared on the register, but
and Mr. Castle's name didn't appear, but the address...
His address appeared on the register.
So you're telling us that Mr. Castle's address appeared on the register as the address at which Pell should be contacted, or what?
Yes, as the registered office of Pell.
You mean, when you say Castle's address, do you mean the address of the lawyers, Castle and
Lewis? Yes, that's the address.
My Lords, there is absolutely no evidence of that anywhere. And that's the first time that I hear of any of that.
Yes. Well, I put it this way: that is the practice. That is the practice in Montserrat on the register.
Sorry, just to go back a stage. You're characterising this now as a mistake, or are you characterising it as a fraud, or either?
Well, look, I accept there was a fraud on the part of Warren Castle. What I say, it was not a fraud that could have been discovered by the appellants or their lawyers, because according to the register, of the land register and the company register, and the order of the court restoring the company, everything pointed to the fact that Warren Castle was a director and represented this company.
Now, we put to you we understand that submission. We put to you the findings that the Court of Appeal has made, and we've seen the way the judge dealt with it. But looking at the application of Section 140,
yes,
you're now addressing us on the question of mistake, or relevant mistake,
yes,
and a relevant fraud. And I just want to be absolutely clear what your submission is in relation to Section 140.
Yes. What I say in relation to Section 140 is that so far as any contribution is concerned, that was caused firstly by Mr. Castle, wrongly representing that he was director of the company. Secondly, the Registrar of Companies allowing the company to be restored to the register and showing Mr. Warren Castle, or Castle and Lewis, directors of the company, and the order of the court itself.
But why do you say those were mistaken? Was he not a director of the company?
I do apologise, Mayor, I didn't quite hear that.
Are you saying that the registrar of the company, that they made a mistake in restoring the company to the register?
Yes, that's what, precisely because...
Why was that a mistake?
Because Mr. Castle did not represent Providence Estate Ltd, Providence Estate Pell. And that's the whole reason why the transaction was fraudulent on the part of Mr. Castle.
So he was not in fact their lawyer, and hence his purported application on the company's behalf to restore it to the register was...
Well, when he made the application, my lady, he was making the application so that he could be the director of the company. And I think there was one hearing, it was then pointed out to him that... yes, it was pointed out to him that he couldn't do it because since he wasn't a director of the company, the shares had been transferred without the company being restored. It was put to him that he couldn't make this application. Then there followed the affidavit of Walter Wood in support of the application. Yeah, yes. Yeah. And the transfer were signed, of course, by Mr. Castle as a director of the company and accepted by the land registry that he was able to transfer the land in question. So my submission is that so far as if any mistake was concerned, then that was by the land registry itself, and also by the company registry. Yes, and of course, The appellants were not the proprietors at that time. And I submit, looking at section 140, that they, as the proprietors, should have contributed to that mistake. And the wording of the Act is substantially contributed. It's not enough simply to say, well, your lawyers ought to have known. The substantial contribution, which the Court of Appeal appeared to accept, did not lay at the...
I'm sorry for interrupting, but you're agreed that there was fraud by Mr. Castles?
Oh, my Lord...
And are you also agreed that there was a mistake? And you categorise it as by the land registry and by the company's registry?
Well, my Lord, my primary submission is this, that it's fraud, and you don't get to characterise fraud as being as such a mistake. It's either fraud or it's a mistake, and it's not a question of simply categorising a fraud as a mistake. This was a fraud. Okay. There's no two ways about it. But if the board is of the view that it's a mistake, then my submission is that the appellants, and each of them, did not substantially contribute to this mistake, because this was the government. It was the company's registry, and it was the land register that did this.
So your submission is that even if the lawyers, contrary to what you've submitted already,
yes,
ought to have made enquiries which would have disclosed problems, in other words, that the fraud would have been nipped in the bud at that point.
Yes.
You say, nevertheless, that the lawyers would not have substantially contributed by neglect or default.
Yes. And indeed, if one looks at page 147, that is a letter from Mr. Hogarth Sargent to the Registrar of the High Court, and it's dated January the 7th, 2008, and it reads, Dear Mr. Sargent, reapplication reinstatement of Providence Estate Ltd. Your letter of November 26, 2007 on the above caption refers, please note that the above company was reinstated on the 21st of September 2007 by order of the court of the same date. As such, we cannot therefore process the application. We hereby return the application. And that was an application by Mr. Rooney, I believe, to properly restore the company to the register. So we can see there that even the High Court is saying, well, this has all been done and it's valid.
I'd just like to go back to the point that my Lord Burrows asked.
Yes.
If there is constructive knowledge,
yes,
assume that, okay, wouldn't that be a substantial contribution to fraud?
It would be, in looking to see whether there is a substantial contribution to fraud, I would submit that one has to break down the fraud into its constituent parts and to see who is at fault. If there is constructive knowledge, there is fault on the part of the lawyers, but I would submit that it's not substantial, taking into account the role of the government in allowing the fraud to take place.
So it's a relative thing?
I submit, by the use of the word substantial, it has to be relative. It can't be right that the government and Mr. Castle are 9/10 to blame, and that the appellants somehow lose the protection of Section 140. I submit that the Act doesn't work like that.
Have you got any authority in how we're to construe Section 140 on the sort of issues that we're here concerned with? Substantial contribution and the like?
No, there is no authority on that proposition. But then one has, of course, the the other decision that I've referred to, where the High Court in the BVI made clear about what needs to be done in the circumstances as a matter of practice for conveyancing. Pickering.
That seems to be dealing with a different sort of question as to the kinds of mistake that we're talking about.
Oh, it is a different question, but what it does deal with, my lady, I would submit, is it deals with what the Caribbean attorney is expected to do in this type of situation. It's making clear that as a matter of practice, all the attorney has to do is to look at the register, because that is the primary way in which the torrent system works in the Eastern Caribbean.
But you've still got to work out. Yes, you look at the register, you see the land is owned by PEL. You've still got to work out, well, this person in front of me who's purporting to sell me this land, what is their connection with PEL? And that is what is said by the High Court, by the first instance judge here, have been where they fell down, that they just took Mr. Castle at his word and didn't bother checking whether he actually had any authority from PEL, which in fact he didn't have. So that's the default that we're talking about.
Yes. But, my lady, I would ask the board not to forget that when a company is being restored in Montserrat, the company has to advertise in the local newspaper, and that advert would have contained the application and who it was being made by.
And the timing of this, I thought that one of the points made by the judge was that some of the transfers took place whilst the company was actually not yet restored to the register of management.
Yes. I'm not so sure.
As far as the timeline is concerned, which of these documents had been made by the court at the time when the conveyances were signed?
I thought that I'm looking to. I thought that all of them, by the time all of the transactions were completed, PEL was in fact restored, and in both the company's register and the land register. And if they had not been on the land register, then obviously the transactions would not have taken place.
If it helps, that is accepted on this side. The land transfer was signed at a time, in the Allen Appellants case, was signed at a time when the company hadn't yet been restored, but by the time that we reached the registration, the company had been restored.
The registration of Mr. Allen's interest on the land register?
My lord, yes.
Yes.
My lord, yes.
Sorry? Yes. Yes, all interests were registered after restoration of the company, my lady. But going back to the mistake point...
Sorry for interrupting you. Is there any authority on torrent systems that have this formulation of wording substantially contributed to it by his neglect?
There's a Belize authority, my lord. Let me get that for you. Can you get that for me, please? It should be Quinto, I believe. Where is that? What page is that? 1279. Right, that's the second bundle of the authorities. My second authority is yes, I do apologise. 1279. a decision by the board, in fact. Let's have a look. In that case, it was a fraud in any event, so it doesn't go to the question of mistake.
Well, paragraph 41,
yes.
1288, they seem, the board say both. The mistake was that of the registrar, consisted in the erroneous belief that Anne Williams rather than the Pintos had title.
Yes, and it talks about the causative effect of the mistake.
And then it was Anne Williams's fraud.
But I don't think this is going to help us on the substantial contribution issue as such. But it is a helpful authority, as far as I can see,
yes, on
being an identical provision,
yes,
and with some discussion of fraud and mistake,
yes,
on the face of it. But the questions of law at 39 and 40 are not quite
the same,
on point.
But the point I make in this is that so far as substantial mistake is concerned, it needs to be looked at in the round. And in a case where one starts off with a person perpetrating the fraud, when one has the registrar of lands and the registrar of companies both making a mistake, it is, in my submission, not correct to say in those circumstances that the appellants have substantially contributed to that mistake by the failure of their lawyers to make further inquiries.
So I think what you're saying then is that a but-for test is not the right test here.
Yes, yes.
You might be able to say, if they had made the inquiries, I mean, you say they wouldn't have found anything, but assuming that we go with the concurrent findings that they would have found something, you say it may be a but-for cause, but that doesn't make it a substantial contribution. Yes.
But in any event, the court didn't make that order. But the concern of the appellants, the major concern of the appellants is this, is that when the Court of Appeal made the order that it did in restoring the lands to Pell under a personal claim, it had no evidence before it. And it's odd also because...
No evidence as to what?
No evidence about anything at all. You had the defence and counterclaim. They didn't have a certificate of truth, what is called a statement of truth in this country, so that wasn't evidence. Mr. Rooney was not allowed to give evidence by the court because he had failed to put in his witness statement. So there was no evidence at all. And if one looks very briefly at the notes of evidence, and I'll just point them out very, very briefly, because it does go on for some time. It starts at the consideration of the lack of evidence starts at page 206. And there Mr. Markham mentions Rule 2911, that's the lack of failure to apply for relief from sanctions. But then he goes on to say at 207, he talks about the extensions which Mr. Rooney had obtained in the past, the last extension being made by Mr. Justice Thomas Astafan. And then he talks about Mr. Rooney deliberately circumventing the rules of the court to start other actions when he should have been getting on to do with this case. And over at 208, a ruling made by Madam Justice Comby. And
this is Mr. Markham's submissions?
Yes, these are Mr. Markham's submissions, which the judge accepted.
Right, perhaps it'd be more useful to see what the judge made of that.
And so the judge accepts, finally, that Mr. Rooney, who had led to the trial being adjourned on some 16 occasions, should not be allowed to give oral evidence. And I make a simple point that...
Where is that?
That's... go back to 209, I do apologise. Yes. Sorry. The judge says that you have to look at... He says you have to understand that justice is a two-way street. That's at 210. There's justice to the claimant, and there is justice to yourselves. There's a balance in exercises. There's a civil trial on title of land. The court is also mandated to save expense, and so on and so forth. And he goes over for a few pages, but before that, Mr. Markham mentions that the trial date has been moved some 16 times because of Mr. Rooney's unavailability, and that Krauss and Brelsford have travelled to Montserrat for a trial on some of those occasions. So the point I make is this, is that we say on the personal claim, the judge had to make, as it were, or undertake a balancing exercise. And we say he couldn't do this without any evidence from the company at all. because we say that so far as a personal claim is concerned, if it is to bypass Section 140, all of the cases seem to suggest that that can only happen in limited circumstances. Firstly, where there's some contract, and privity of contract, some fiduciary duty, or fraud on the part of the proprietor. And we say that in every case, so far as the appellants are concerned, there was no actual fraud on their part. They bought land. They paid for land. There's a reference to Mr. Justice of Appeal Carrington mentioning what the defence said, that the land in one case was 79% undervalued, and in another case it was 85 or 86% undervalued, but this wasn't evidence. It was an assertion made in a pleading without a certificate of truth. And so we say the Court of Appeal was required to look at both sides. And we say this because if Mr. Rooney had given evidence, there was a wealth of material, a wealth of subjects that he could have been cross-examined on to show that, in fact, he himself had contributed to this mistake, that he himself, and it's a point raised by Mr. Markham right at the beginning of the trial about the ability of Mr. Rooney as the 40% shareholder conducting this litigation on his own and in person, and there was evidence that could have been called about the history of Pell, its failure to pay property taxes, the failure of Mr. Rooney as the company secretary and treasurer to do what he was supposed to do under his agreement with Wood. But none of that came out, and it didn't come out because, of course, Mr. Rooney didn't give evidence. Yes, and it's at page 215, where he actually denies Mr. Rooney the right to give evidence. It is, yes, he says it's with regret I will not be able to accede to this request. But the point is this, is that if this was to be...
Certainly at 217, it says, end of claimant's case, no witness statement of Owen Rooney.
Yes.
But then Mr. Brelsford is sworn. Oh, okay.
And I know that the other side will say, well, look, he put an affidavit in, but that affidavit, we say, was never served. And in any event, once it went to being a trial, under the rules, he had to give oral evidence. And in order to give oral evidence, what he had to do was put in his witness statement on time. And there's reference from Mr. Markham saying, well, look, Mr. Justice Thomas Astafan had extended again the time for Mr. Rooney to put in a witness statement, but in that time, he decided to launch other actions, including actions against the appellant. So,
I'm just having a little bit of difficulty following the significance of this submission, and I'd like to return to the question that Lady Rose asked.
yes.
What is the evidence that was missing before the court? Because we have, there's evidence that the properties were transferred.
Yes.
There was evidence at page 195 that the inquiries were left up to the solicitors
Yes.
and the attorneys, and there was no evidence that any inquiry was made. So what's the evidence that's missing?
The personal claim, I would respectfully submit, would be a claim to say that in all the circumstances, it is fair that the land should go back to Pell, because don't forget, so far as the first respondent is concerned, it could always have applied for an indemnity from the Registrar of Lands under Section 141. And we say that where there is an order by the court, where there's a finding by the court that the land ought to return to the original proprietor, that has to meet the fairness of the situation. And in this particular case, it doesn't meet the fairness of the situation. There was just no examination by the Court of Appeal at all as to how it would affect the appellant, and in particular, how it would affect the company. And so far as the company is concerned, that also meant how it would affect Mr. Rooney.
So is this your submission, that based on the Brelsford case,
yes,
in deciding who should have the land, you look at all the circumstances, see who's more unconscionable than the other?
Yes.
As far as the PEL side of things was concerned, because Mr. Rooney didn't give evidence, you weren't able to cross-examine him, and there's a whole lot of mud you could have flung at him and at PEL,
yes,
which might have tipped the balance of fairness in favour of your clients and against them. Is that what it amounts to?
I only wish I had put it as clearly as that. But that's it in a nutshell. And I thank you, my lady, for assisting me with that. But that's our case.
Whether I'm assisting you or not,
well, it may not assist me, but it certainly summarises my position.
Yes.
And so we submit that if one were to look at the fairness of the situation, as in Brelsford, then it must be that you have to look at both sides.
Well, Brelsford was somebody who had actually given a blank authority to be filled in by whomsoever, and had thereby facilitated the fraud. But here, the PEL owns the land. And what had it done wrong? What had PEL done wrong?
Well, my lord, one has to go back to the history of the matter, which isn't in evidence because we weren't able to cross-examine Mr. Rooney. But what we say, we would have put to the Rooney the fact that so far as his claim to all these lands were concerned, they actually were not made out. Pell had the land, but they were not made out. And we could have gone into the arrangement between himself and Walter Wood, and indeed the fact that Walter Wood was supporting the appellants in their claim against the company and Mr. Rooney. But there was a lot of material there which had been gathered by Mr. Brelsford that there was no opportunity to use.
And this right to get back the equitable interest in the land, if looking at all the circumstances of the case it's fair, is that something which arises only in the context of land registration or a claim to rectify the register? Or is it some freestanding cause of action which exists or might exist even in a case that's got nothing to do with the registration of the land?
I say that's freestanding. It arises in all circumstances, but particularly where, as in the present case, there was a fraud which the appellants were simply not a party to. And I take and I accept the direction of the board that you had this constructive knowledge. But I say, in looking at everything, here you had, in the main, retirees buying land who are suddenly caught in the midst of a fraud and, in effect, lose their life savings. And I say that that's something that the court ought to balance that out with what would be the effect on Mr. Rooney, who stood, if he was right, if he had a good claim, and Pell at that stage, to be compensated by the government, and where the government, under Section 141, would look at all the circumstances of the case I mean, Rooney's involvement only commenced because it had come to that point in time where so many land taxes were owed that the government was going to take back this land, and that's when Warren Castle seized the opportunity, albeit fraudulently.
Can you just help me with section 141? What does that actually allow for? You're saying that Rooney could claim an indemnity. Can you just take us to that, please?
Yes. Subject to the... I do apologise. I'll just get it in the authorities. I had it in a separate note, but let me get it in the authorities. Where's
922.
Yes.
922.
Yes. Yes. So, subject to the provisions of subsection 2 of this Act, and of any written law relating to the limitation of actions, any person suffering damage by reason of any rectifications of the register under this Act, or any mistake or omission in the register which cannot be rectified under this Act, other than a mistake or omission in first registration, any error in certificate of official search issued by the register, shall be entitled to be indemnified by the government out of monies provided by the legislator. No indemnity shall be payable under this Act to any person who has himself caused or substantially contributed to the damage by his fraud or negligence, who derives title otherwise than under a registered disposition made bona fide for valuable consideration from a person who so caused or substantially contributed to the damage. And then at Section 142, which deals with the amount of the indemnity, where an indemnity is awarded in respect of the loss or any interest in land, it shall not exceed, where the register is not rectified, the value of the interest at the time when the mistake or omission which was caused, the damage was made, where the register is rectified, the value of the interest immediately before the time of rectification. And so, looking at section 141, subsection 2, one can see, if the board is correct, that there was a substantial contribution to the damage by fraud or negligence, then no indemnity is payable. So in other words, these retirees, in essence, lose their life savings, whereas if Rooney, Mr. Rooney goes back with the company, then subject to what the government has to say about it, he stands a good chance of getting his indemnity. And so
the purchasers all retained attorneys, is that right? In order to, the purchasers all retained attorneys.
Yes.
To act on their behalf.
Yes. And of those attorneys, my lord,
yes,
David Brandt is in prison, right? Now with Warren Castle, and Mr. Markham died on the 3rd of September 2021. Yes, I think Joel Osborne actually was in person. Joel Osborne acted in person. He didn't have an attorney. And so the difficulty is, just as the other side contend, well, you know, Mr. Castle is a man of straw, there are no men to go after now because, as it were, one is in prison, the other one has died. So it's not a question.
Brandt had no partners at the time.
Sorry?
Did Mr. Brandt have any partners?
He had no partners at the time. And at the time, so far as Mr. Markham is concerned, he had Miss Gerald, who was with me, but as an employee, not as a partner. And the other partner, of course, was Mr. Kenneth Allen QC, who retired before the events which took place over this land. So that there is no recourse for the appellants in this case to anyone. So they simply lose their land and lose their money. But I accept that what the board has to look at is the law, is the proper construction of Section 141. But I say, when you look at it as a whole, that is something also that the Court of Appeal ought to have taken into account when they said it was fair to give this land to Pell. I know that when my friend will be making his submissions from his the Respondents case, that he suggests that Montserrat is a small community, everybody knew everyone, all of the appellants knew the lawyers, and it's simply not the case, and that's borne out by the evidence. It was never put. It's also being put that Montserrat is a corrupt island, as it were, with government, lawyers and other nefarious persons working hand in hand. That's conspiracy theory, I would submit, and there is no evidence to do that. I think I'm coming up.
That some of the appellants were actually visitors from the US who.
Yes, the Krauses were on holiday and saw the land at hoardings at the airport. Brelsford, as I said, was employed as the director of public works and thought, well, this is a nice place to retire. But he was certainly. Montserrat is a small community, but not everybody knows everybody. It's like being able to say, well, I know every single person that lives on my street, and I doubt whether anyone does. And so, I've just had one further thing. So I did point out the counterclaim and the relief being sought, and that's essentially the same relief that is being sought in the cross appeal, which Justice of Appeal Carrington firmly rejected at paragraphs 27 to 28 of his judgment. And that's electronic bundle 301. And I'll refer to that very quickly, and that would be the last thing I will say because I'm coming up to my time. That's 301. The respondents filed a counter notice of appeal raising various issues of company law concerning State of Pell, the authority of companies registrar, companies registrar and land registrar, and fraud. These, apart from the issue of fraud, do not appear to have been matters raised in the court below, and so are not suitable for consideration on appeal. With respect to the issues of fraud, these were not supported by evidence in the court below and were not proven. The respondents are not able to raise them before this court. And so those same arguments will be repeated in the respondent's cross appeal. But I'm running out of time. Unless your lordships or your ladyship have any other questions for me, I propose to stop at this point.
Thank you very much.
I'm grateful.
Yes, Mr. Peace.
My lord, my lady. My lords, I am going to be making 5 submissions. I'm going to outline those 5 submissions in a moment. But before I do so, there are a number of points that I'd like to make by way of reply. And that is this. Firstly, the question of Mr. Rooney not being able to give evidence or being barred from giving evidence at trial is, in my respectful submission, irrelevant. And it's irrelevant to the issues in this case. To the extent that it's relevant, your lordships will no doubt, and I urge your lordship to take into account, the fact that there was opposition to Mr. Rooney giving evidence by Mr. Carl Markham, who was representing the claimants. In other words, if Mr. Markham had said, well, I wish to cross-examine Mr. Rooney, and it's important to my case that I do so, Judge, and he's already filed an affidavit, in my submission, the position might well have been different. The second point I make is this case is not about notice of a defect in title. It's about notice of lack of authority. This is what this case is about. Thirdly, and there's no evidence about this, nobody has suggested that any of the lawyers in this case were not insured.
They're not insured. They're not insured.
And there's no evidence in relation to that at all. Fourthly, my learned friend seeks to disturb the findings of the judge made at first instance, but he not only faces the formidable obstacles that are well known in terms of the authorities on attempting to disturb findings of fact of a judge, but actually, if one turns to page 255, your lordships will see that the only appeal against a finding of fact made to the Court of Appeal...
What page, sorry?
That's 255, at tab 33. The only, at point 2, any findings of fact, this is the notice of appeal. The appellants take issue with the finding that the appellant instituted his claim as a result of Warren Cassell's conviction for fraud. That is the only appeal in relation to an issue of fact that was before the Court of Appeal. In those circumstances, any attempt to revive an attack on the findings of fact made by the judge, in my respectful submission, is doomed to fail.
Are you going to identify for us the key findings of fact which you say support the respondent's position?
My Lord, we essentially rely on the findings of fact made by the judge. And the findings of fact made by the judge are set out at paragraph 19. And I'm moving ahead of myself with my submissions, but your lordships will see that paragraph 19 counsel for the claimants agreed, and that's at page 229, I beg your pardon, sorry, 229, yes. Counsel for the claimants agreed that recourse may be had to Pell's records at company's registry, being public documents. And that's important to my submissions. These are public documents, therefore they are accessible by any reasonably competent lawyer. And then the facts are set out, the findings of fact are set out at 20.
You don't need to read them all out for us, but these are the key findings that you say were built on by the Court of Appeal.
Indeed, and also then in relation to each of the appellants, your lordship will see that this is dealt with in the same way by the judge in relation to all the appellants, except for the Allen appellants, that appellants 6 to 9, and in relation to, and the findings are made, so in relation to the Allen appellants, 32, paragraph 32, 33, and at 33, what the judge says is, counsel for the claimants in his closing, at paragraph 24, attempts to infer that because counsel was retained, pausing there, I will be making this point in due course in my submissions, that of course Mr. Markham, that represented these claimants, who was also himself a claimant as part of the Allen appellants and Allen claimants, he represented them. He was there. He could have. He never gave evidence. He could have said to the judge, I'll develop this point in due course, but he could have said to the judge, look, judge, I was negligent. It was inadvertent. I made a mistake. None of that. Instead, he relied on the fact that the court should infer that because counsel was retained in the transaction, it applies a due diligence. And of course, that was rejected by the judge. There is no such inference as a matter of law, and in any event, the evidence does not support that inference. In fact, the instrument of transfer was executed by the claimants while Pell was struck off. Now, all of appellants 6 to 9 signed the instrument of transfer before Pell had been reinstated to the register. Mr. Cassell, he signs on the 8th of October.
For which of the appellants, sorry, did you say?
6 to 9. So that's Mr. Markham, his partner, Kenneth Allen QC, Mr. Allen's daughter, and also as I understand it, Mr. Allen's wife, Weeks. And my lords and my lady will see, indeed, the fact that the transaction proceeded despite the glaring omissions and inconsistencies in the company's records as referred to above, that's the finding at 19, are indicative that no search was done, as it is difficult to imagine a lawyer advising a client to proceed in the light thereof. And indeed, my lady, in the absence, my lady asked about the lacuna in the evidence from the lawyers, one of whom happens to be a claimant. And in the absence of any kind of explanation as to why these searches were not conducted, in my respectful submission, the inference has to be that this was quite deliberate, or at the very least that it was reckless. At the very least that it was reckless.
So you're saying that the appropriate time was when they were dealing with Mr. Cassell, although because you accept that by the time the interests were registered, everything was on the company register. But what is it? It's put to you, put against you, that if they had made these inquiries, what they would have seen was that the company was restored, Mr. William Castle was a director, the only director, and that those documents are all the result of the company registrar not realising that the share transfer from Mr. Wood to Castle and Lewis had actually been effected at a time when the company was struck off the register.
And that is dealt with by the judge at paragraph 20, Roman numeral 9, all the way to Roman numeral 13. And essentially what the judge says is, look, any competent lawyer conducting a search of these public documents would have realised that actually there was no basis upon which Mr. Cassell could claim to be a director of this company. And he says, so at 9, he says, 24th of September, notice of change of directors filed, removes Walter Wood and OR as a director and appoints WC effective the 21st of September. Form does not comply with Section 76 of the Companies Act and is not in the prescribed form, and that no signature action is provided for, and neither is the form signed by a director or other authorised officer in accordance with instructions to the form. 4th of December, shareholders' resolution filed removing Walter Wood and OR as directors effective the 21st of September and appointing WC director effective the 1st of July. Resolution states that the notice waived and that OR being removed as he has refused to return to Montserrat and has made no contact with members of Pell for several years. Resolution signed by Meadowriff Lynch as secretary. WC by this resolution purported to ratify his acts as director. There are two problems with this document, and which on inspection would have been evident to the claimant's respective lawyers on the transaction. First, WC purports to waive notice of the meeting. Such waiver was to be that of Owen Rooney and not Warren Cassell, as provided for in Section 112 of the Companies Act. It applied where one attends the meeting, notwithstanding that notice was not received. Owen Rooney never attended the meeting. Secondly, if Warren Cassell could not locate Owen Rooney, the proper course was to apply to the court pursuant to Section 131 of the Companies Act for an order calling a meeting. Now, what I say is that a lawyer, indeed, the duty is not of the lawyer. The duty is actually on the party that is purchasing the land to ensure that when you are dealing with a company, that you are dealing with an agent of the company that is, of course, authorized by that company. When we come to look at the relevant sections, Section 100 and Section 107, 106, 107, 108, and 112, essentially, those are sections that are designed, they are protections, they're mechanisms that are included within the legislative scheme to ensure that when somebody purchases from a company or when somebody is acting as agent on behalf of a company, that there are certain requirements that need to be met in order to make sure that you are in fact purchasing from a company. And in this particular case, again, I'm ahead of myself, but in this particular case, the actual instruments of transfer by each of these appellants that you then register, the actual instrument of transfer were riddled with non-observance of the requirements in the registration, in the Registered Land Act. May I have a moment? My learned junior is pointing.
Just to highlight the point Lord Stevens highlighted earlier, in respect of the point that
yes, and the point is also, my learned junior reminds me that at page 294, the Court of Appeal at paragraph 3, it says as follows: the company was restored on the 21st of September 2007, and on the 24th of September 2007, a notice of change of directors from Mr. Wood and Owen Rooney to Mr. Cassell was filed. The learned judge noted that this filing was not in the prescribed form and not signed by a director or authorised officer of Pell. Some 2.5 months later, on the 4th of December, a shareholders' resolution was passed removing Mr. Rooney and Mr. Wood as directors retroactively with effect from the 21st of September 2007 and appointing Mr. Cassell as director with effect from the 1st of July, i.e. a date on which the company was still struck off. There was no evidence or indication in the judgment that a notice of this appointment was filed at the company's registry, and in fact, there isn't.
Does the company's registrar just put on the register any documents that the company provides without him or herself checking the validity of these? Or what is the purpose of these documents being public documents if the company registrar is not in some way indicating that they are what they purport to be?
No, my lady, a registrar of companies it may in certain circumstances, because I've certainly come across situations where a document is so defective that a registrar of companies may, or Companies House, may return it, for example. That's true. But normally there is no vetting of documents of this sort by a registrar of companies, that's my understanding. And the final point that I wish to make before outlining to your lordships
don't think you've given us the full range of paragraphs in the first instance judge of findings of fact, but we can find those. You've given us, I think, 4 of them. I think there are more.
My Lord, in all of them, they follow exactly the same structure in all of them, except in relation to the Allen appellants, where the judge says, well, look, a lawyer worth his salt would not have advised his clients to sign an instrument of transfer at a time when the company had not even been restored to the register. My Lords, there are 5 submissions that I am going to be making. I'm going to start. 5.
Yeah. So, sorry, what was your 5th preliminary point?
My 5th is, I beg your pardon, my Lord asked me a question and I had forgotten to make it. That it's certainly accepted by us that the Registrar of Lands makes a mistake in registering what effectively were void dispositions. That's accepted. And in fact, when we come to look at the English and also the Caribbean authorities on mistake and rectification of the register on the grounds of mistake, that's one of the points that all of these decisions make, that it's got to be a mistake at the point of registration. But of course, you can have a mistake at an earlier point, in other words, at a point at which you enter into a transaction that is a void transaction that then works its way into the actual register. It's most clearly, in my respectful submission, explained by the Court of Appeal in an English case, and that case is Antoine versus Barclays Bank, but it also follows, or the Caribbean cases also follow the same reasoning, and we have 2 cases. Louisiana case, which your Lordships will find at 1222, and Webster against Fleming, which is an Anguilla case, which is at page 1378. The Louisiana case is a St. Lucia case. All of them proceed on exactly the same basis. My Lord, I'm going to start, unless your Lordships tell me to approach this otherwise. I'm going to start by making some general observations on the torrent system. And out of that, I will then make the following 5 submissions. Our first submission to your Lordship will be that the trusts, including constructive trusts imposed by the court, are an exception in the Montserrat registration of Land Act to the principle of indefeasibility. The second submission is that the Montserrat legislation does not extinguish claims in personam, be they common law or equitable claims, such as the claim underpinned, for example, by the concept of unjust enrichment, but also the claim that the Court of Appeal found existed on the basis of Gibbs versus Mercer. But also the personal claim that the court found existed on the basis of the decision of Gibbs versus Mercer, yes, the board's decision of Gibbs versus Mercer. Our third submission will be that the decision of the Court of Appeal is either justified on the basis of Gibbs versus Mercer. We say that the facts of this case fall by analogy within the principle set out by the board in that case, and the Court of Appeal were therefore right to rely on that case as part of the reasoning for finding that a personal equity arose in this case. And indeed, I note from my learned friend's submissions that in fact he does not dispute that a personal equity can arise in these circumstances. The way that he puts his case is Well, actually, it involves a balancing exercise.
You'll elaborate in a moment, but we're just about to adjourn. So if you could let us have all your 5 points.
Yes,
that'd be very
and the fourth point is that the decision of the Court of Appeal is in any event justified, either on the basis of a constructive trust as conceived by Lord Brown Wilkinson in Westdeutsch, on the basis of unconscionable conduct, or as suggested, alternatively, by the editors of Goff and Jones, namely a lack of consent or want of authority as a proprietary restitutionary mechanism responding to the enrichment that would otherwise arise from the appellants, in the circumstances of this case, receiving these properties without Pell's consent or proper authority. My Lords, the only reason, I'm conscious of the time, but the only reason why certainly this concept, this argument, this thesis by Goff and Jones, perhaps hasn't occupied a space in this area, is because, and I accept that, is because where you're dealing with a disposition pursuant to, which is void, essentially the nemo dat principle will apply, and that's it, and of course you just simply ask for your property back. Where title may pass on some possessory basis, as it does in relation to some property, the equitable title may remain behind. If you're dealing with an anterior breach of fiduciary duties, a breach of trust, then of course knowing receipt is a remedy that of course we're all aware of.
And the final point you're going to be making?
Yes, my final point is that we have an unanswerable case, we say, and this is the strongest part of my appeal, and I accept that. It's an unanswerable case under Section 140 of the Montserrat legislation for rectification of the register, at least on the grounds of mistake based on English and Caribbean cases.
Right. Thank you very much. That's extremely helpful by way of a roadmap. We will adjourn now, and we will resume again at 2 o'clock. Thank you.